Hi! In this video, you'll be able to get to know more about the Book 1 in Criminal Law. We've been given a task to answer 9 different questions, so just stay tuned and keep watching. So first, I'll be discussing Article 3 and 4 of the Revised Penal Code. Article 3 states that acts and omission punishable by law are felonies. So, what is a felony? Felony or felonies are committed by either intent or negligence, while Article 4 states that criminal liability shall be incurred. Thus, any person committing felony will be different from that having the unlawful act done which he intended to do so. So, for question number 2, differentiate consummated, frustrated, and attempted felonies. So for consummated felony, all the elements for the accomplishment of the felony are present, while in the frustrated, all the acts of execution to produce the felony are performed, but crime is not accomplished due to causes independent of the will of the offender. And lastly, for attempted felony, the offender commences the commission of the felony directly by overt acts, but does not perform all the acts of execution which should produce the felony as a consequence by reason of a cause or accident other than his spontaneous desistance. So in question number 3, I am tasked to discuss justifying and exempting circumstances as well as mitigating and aggravating circumstances. So, what is justifying circumstances? It makes the act of persons to be in accordance with the law rather, that such person is deemed not to have transgressed the law and that such person has no civil liability and is borne by the persons benefited by the act. While exempting circumstances, on the other hand, are situations where there is wanting in the agent of the crime any of the conditions which make the act voluntary or negligent, that such exemption from punishment is based on the complete absence of intelligence, freedom of action, or intent. That such person acts without negligence, freedom of action, or intent does not act with malice. Mitigating circumstances, if present in the commission of the crime, do not entirely free the actor from criminal liability. That such circumstance serves only to reduce the penalty and are based on the diminution of either freedom of action, intelligence, or intent. While aggravating circumstances, on the other hand, if attendant in the commission of the crime, serve to increase the penalty, that such penalty, however, do not exceed the maximum of the penalty provided by law for the offense. That such circumstances are based on the greater perversity of the offender manifested in the commission of the felony, and it is shown by the motivating factor itself, the place, ways and means of employed, time, personal circumstances of the offender or offended party. So for question number 4, differentiate principal, accomplices, and accessories. There are different participants of the crime as above mentioned. Some of the offenders in the crime are principals and the other are accomplices. So the principal element of every punishable complicity consists in the occurrence of the will of the accomplice with the will of the author of the crime. We can know if it is the principal if their responsibility for the offense committed is collective and knowing who gave the fatal blow is immaterial. An accessory, on the other hand, must have knowledge of the commission of the crime and having knowledge took part subsequent to its commission. In the absence of positive proof, direct or circumstantial, of his knowledge that the goods were of illegal origin or fraudulently acquired by the vendors at the time of transaction, a customer who purchases such goods cannot be held criminally responsible as an accessory. So they said that, or it is said that an accomplice is also an accessory. So how would we know if the difference between an accomplice and an accessory? An accomplice differs from an accessory in that an accomplice is present at the actual crime and could be prosecuted even if the main criminal or the principal is not charged or convicted. Item number 5, I'll be discussing the duration of penalties from reclusion perpetua down to arresto menor. So the duration of penalty of reclusion perpetua is 20 years and 1 day to 40 years, while in reclusion temporal, 12 years and 1 day to 20 years. Prisión mayor, 6 years and 1 day to 12 years, while prisión correccional, destierro suspension, 6 months and 1 day to 6 years. Arresto mayor, on the other hand, lies in 1 month and 1 day to 6 months, while arresto menor, 1 day to 30 months. Pardon, amnesty, and commutation of sentence. So, what are the differences of these three? So, a pardon is a government decision to allow a person to be relieved of some or all of the legal consequences resulting from a criminal conviction. While amnesty, on the other hand, it is an act of sovereign power granting oblivion or a general pardon for a past offense and is usually exerted in behalf of certain classes of persons. And lastly, commutation, it is the substitution of a lesser penalty for that of a greater punishment imposed on the convict by the chief executive. There are different factors that can maybe affect the imposition of penalties. But first, let me discuss recidivism, habitual delinquency, and quasi-recidivism. So, recidivism is one who, at the time of his trial for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title of his code. While on the other hand, let me discuss the requisites of habitual delinquency. So, the accused is on trial for an offense that he previously served sentence for another offense to which the law attaches an equal or greater penalty, or for 2 or more crimes to which it attaches lighter penalty than for the new offense. And lastly, that he is convicted of the new offense. Lastly, quasi-recidivism, the offender in this must be serving sentence by virtue of final judgment to trigger the application of Article 160 on quasi-recidivism. Because of the above mentioned, imposition of penalties may change from time to time depending on the nation's crime rate of this. Crime in general is a big word, so let's search the different kinds of crime, complex crime, and compound crime. So, a complex crime presupposes more than one unlawful act where the offender is meted out the maximum penalty for more serious crime, while compound crime, on the other hand, is a single act constitutes two or more grave or less grave felonies. Are you familiar with Article 89? So, now I'll be discussing to you the extinction of criminal liability under Article 89. Causes of extinction of criminal liability under this article arises after the commission of the offense, while the causes of justification or exemption from criminal liability arise from circumstances existing either before the commission of the crime or at the very moment of its commission. I think that would be all. Thanks for watching.